Good morning. I am Marilyn Petito Deviani, and I will be presiding over the hearing for Michael Anderson, the Associate Justice of the Probate and Family Court. I would like to introduce my colleagues on the council. Council Juvenile. Morning. Morning. Council Iannella. And we have, I don't know what we call it, remote Zoom. We have Council Hurley, I'm Mary, and is Councilor Duff there? We don't see Councilor Duff. I guess she'll be joining us. Oh, you're on the bottom, Eileen. Eileen, can you see us? Can you hear us, Mary? I hope they can. Okay. First of all, I want to welcome you, Michael Anderson. You can take off your mask because I think you're about 12 feet from us. And I just want to introduce, first of all, I will read the letter from the governor as appointed you. Dear councilors, I am pleased to nominate Michael D. Anderson to the position of Associate Justice of the Probate and Family Court. I submit the nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. I am enclosing the nominee's resume for your convenience. Sincerely, Charles C. Baker. Welcome. I'm going to call on you have a witness here. After your witness testifies, I have two letters of people who wanted to come, but there were circumstances that prevented them from coming, so they have submitted a letter, and I will read them after we hear from your witness. So I'm going to call on Attorney Eugene A. Meeker. Did I pronounce that right? Okay. Yep, absolutely.
Right here.
Yes.
Well, good afternoon, good morning, I guess still.
Morning.
Councilors, for having me. This is quite an honor. I am a very enthusiastic supporter of the gentleman to my left. Let me just tell you just briefly, I've been an attorney for...
Excuse me, is he close enough to the mic or do you want to close?
No.
I'm sorry. Okay, thank you.
I've been an attorney for 45 plus years. I've practiced the last 30 years in the probate and family court, doing divorces, estates, and general probate court matters. I am a business person as well, and I have, proud to say, I have two family foundations, which have donated over $1 million a year for several years to UMass Medical, supporting ALS research. I think one of my proudest moments as an attorney is that I am the lead trainer for the Conciliation program for Essex and Middlesex County, and I've worked with the administrative offices of the trial court, training lawyers how to settle cases and help people settle cases across the Commonwealth. I'm sure that you listen to many complimentary statements where people are here to support, but Michael truly deserves any accolade and any positive adjective that one can use for him. He is clearly an outstanding individual, attorney. My personal familiarity, excuse me, my personal familiarity with Michael over the past many years has been as an adversary. We are not social friends in any way. I have also been a conciliator on cases. Where he's been the attorney for a client. He is an experienced, practical, compassionate, insightful, fair, and balanced nominee. He understands the probate court system and the inherent red tape. He understands my colleagues and the interaction between the judiciary and attorneys. He understands the importance of good judicial interaction and the responsibility judges bear. And I know this because we talked about how the system works and how we interact with the system over many, many years. I first met Michael on a case which was a difficult case. Two parties, pro se's, had mediated an agreement. It was a surviving agreement, which means it generally cannot be changed. Michael was engaged by one of the spouses to challenge the agreement. It was a difficult position to be in, particularly given the legality of the situation. He did a superb job balancing the realities of the law, the court system, and the rigid realities of a surviving agreement. He handled angry clients extremely well. He has an understanding and a drive and a focus that was excellent. These are things that I think should be considered for a judge, a nominee for a judge of the Commonwealth. He is even-tempered, he's direct, he's professional, he's personal. He can address issues sharply, concisely, and with precision, without emotion, and always has an eye towards resolution. Again, I think talents which any judge should have. The amount of dignity and professionalism of this man can't be overstated. The case was resolved to a large extent due to the way he handled it, and it avoided the trial time, it avoided expense to the clients. It was a remarkable event. I think that he has an innate ability to address probate court problems, whatever the issue is in the probate court, and he has a wonderful attitude. His demeanor, as I say, is even-tempered. He is rarely distracted by the venom and the vitriol that frequently characterizes probate court work. Our probate courts are inundated with estate cases, divorce cases, custody cases, fighting spouses, fighting legatees, removal of children from the Commonwealth, removal of children from their parents, all very, very serious issues. It is a court where people are emotionally involved in the litigation. It's not like suing two corporations. It impacts their direct lives. It is truly a people's court. Michael has and has demonstrated the ability to handle people, handle situations, and in an excellent and effective method. I believe that Michael distinguishes himself from our peers and colleagues, my peers and colleagues, in his demeanor and patience. He is unique and qualified nominee who will do my profession, our system, and our probate court proud. Thank you very much.
Thank you. Any Councilor Kennedy.
Good morning. You have incredible reputation. Thank you very much.
I just have a couple of questions. And you kind of touched on it in the statement. One of the problems that you see in the probate court, just by the nature of the piece, there's a lot of noise. It sounds like some of the things you're doing is trying to get people out of the courtroom, different environment, trying to settle.
That's correct.
What kind of things do you think we can do going forward to make that happen more often? It doesn't seem to happen a lot.
I'd be happy to talk with you privately. I'm not sure what I want to say publicly.
Well, you might want to say that for my next question.
I think that it is very, very difficult work. They are really difficult problems, and people aren't always in the best disposition when they're dealing with very personal problems. They really aren't. I think that, for instance, I'm a big advocate, and you may well know this, of conciliation, where people get a chance to be heard and their problems to be dealt with effectively. Michael is an enthusiastic supporter of the system and uses it. And I think that it also helps attorneys know how to handle people, how to handle problems. It is not, obviously not judicial in the sense that there's a person who can make a decision like a judge can make. But our SJC has mandated self-determination by clients in the result of their cases. It's part of the SJC rules, which a lot of people don't understand or know. And it's really an avenue to get relief for the probate court system and give people a sense of involvement in the court system and their cases. Michael is a big supporter conciliation program. It uses it, it supports it. It's a good alternative.
One of the things that happens in this job, very, very rarely, when you really appoint a great judge, great judge you have. But you do hear about that.
Sure you do.
And you hear about problems that very interesting. We have to pay most of the complaints I hear, and I don't practice it. One of the probate about judges, they think that they're not fair. People don't think you get a fair shake when you're in front of a judge. I'm in front of the judge. You know what? The judge didn't even want to hear what I had to say. Over and over and over. Those are the complaints. Why do you think that is?
You have to understand, sister, there are a fixed number of judges. For instance,
We need one.
Essex probably good judges you can use. Right now, Essex County has just a bench press on. Because of COVID, there are 1,000 cases behind. There's no way that it would ever.
Excuse me,
It won't happen.
can you move closer?
Sure, I'm sorry. They'll never catch up. In addition,
That's pretty scary when you say they'll
It's-
never catch up.
I don't believe they will. It's going to be very, very difficult to blend in future work with past work that they have to do with the staff with the amount of judges they have now. And that's the reality of the situation, and
Pretty
therefore,
dire. Never,
excuse me,
never catch up.
I think, well, you should never say never, right, Counselor? But I think it's going to be a difficult process, and I think that the complaint that judges don't listen to me, the complaint that they don't have enough time is simply logistics. You go into any probate court courtroom, there are multiple cases, the courtrooms are usually packed with people waiting to be heard, and there's 8 hours or 6 hours in a day of trial, of hearing time. And it's very, very difficult for a judge to focus on a case and get it done stem to stern. It's hard.
Hey, another complaint that I get over and over, which I have a lot of trouble wrapping my head up. Very, very hard. The way trials proceed, the way they get broken up. I'm in a criminal trial. I'm trying cases, and I walk in, we start a trial, we finish it. And everything else gets pushed aside for a little while, so that trial is done. It might take 1 day, it might take a week, it might take 2 weeks, but you finish the trial. And I think that's probably true with most jury trials and civil cases as well. Done some of those as well. Probate court cases, the judge allots 4 hours for a trial, 6 hours for a trial. Not the most friendly divorce in the world. A lot of issues, experts. All of a sudden, they started October 2nd, and the judge finishes up about 6 o'clock. After about 6 hours or 4 hours, whatever. This is okay. We're going to finish this another day. I'll see you January 3rd. Why does it have to be like that?
You'll have to ask Judge Casey, who was the first judge of the probate court, an excellent administrator, an excellent judge. I don't know the answer to that.
He's not one of the people I hear complaints about.
I doubt that you do. I doubt that you do.
But doesn't that seem more, as a practitioner, isn't that frustrating to you?
It is in a sense, but I think that the quick answer is that I don't know the exact statistic, but 95% of probate divorce cases settle. Even estate cases tend to settle in the
We're
court.
not settling, we're trying. We're trying.
Well, I think that what happens with scheduling is they bring you in and then they expect a certain amount of time for lawyers to talk out in the corridor and see if it can be resolved.
But that's not the way to plan a trial.
It is not the way to plan a trial.
You have to figure out which ones are going to go to trial. And then if you're going to try, if the case is going to be tried, it's not going to get settled. We started a trial. The odds are at this point, the judge is making the decision about whatever the issues are that are being tried. They're not going to settle. Why can't that judge say, okay, this is going to take 1 day, 2 days, or 3 days? Because the lawyers can tell them what the issues are and how long it's going to take generally, right?
Clearly.
You can say, Judge, this is a trial, it's going to take me 2 days.
Yes, you can.
Right. So it takes a little more than 2 days. It takes 2.5. So you bump things to half a day. Why? I don't understand why in the probate court they can't do that. And that's the frustration that I hear from people over and over and over. The biggest complaint about the probate court is that they start things and don't finish. And, you know, the other thing that I hear from people is, geez, I started on October 2nd, like 10th, whatever it is. You know, the judge was really listening to me, seemed to be on my side. I go back December 3rd, and all of a sudden they flip the other way. Because they don't remember what they, you know, how can anybody remember everything about a case that was 3 months ago, 2 months ago, and they've handled 10,000 cases in between? I know you got your notes, but it's not the same thing.
I agree.
Well, those are the frustrations that I hear. I appreciate you answering my questions. I spent a long time with the nominee in my office, as I'm sure he told you. He answered a lot of my questions. I do agree with you. There's no question well qualified. But I do have a different question related to that. I'm voting for this gentleman. He's extremely well qualified. How diversified is the bench in the probate court?
And I don't understand the question, Counselor.
African-American judges, women judges, Latino judges?
I think this is empirical. There are most of the appointments in the last few years have been women. We have most judges.
How many of color?
There, in the courts that I go to, which is mostly Middlesex and mostly Essex, none.
That seems to be the case throughout the probate court, from what I can see. People have seen come here before us, and you would agree with me that that's a problem.
Of course, it's a problem. I think getting good judges is a problem. Getting good judges that are diverse and understand how society works, I think, is obviously a problem. It's above my pay grade, Counselor.
No, I understand that. I understand that. But you're a practitioner.
I suffer the system. I don't.
No, you're a practitioner, and I'm sure that many of the conciliations for are people of color, people from different diverse backgrounds, people who speak different languages. And you would agree with me that for people, the perception of the court is that it is basically all white at this point.
I think to a large extent that's true.
And that the people who go before the court at least will have the perception when they're not, when they come from a diverse background, might feel like they're not getting a fair shake just because of that. Has that been your experience?
Well, it's hard for me to comment on this. I think that academically, certainly your points are well taken. It's what our society is doing today, particularly today in light of history in the last few months. And it's a good thing, and we have to step up as a society. We have to step up. I agree with you.
This goes beyond the last few months. This has been what I've been here 10 years, and there's been a problem with diversity in the probate court the whole time I've been here, and I brought it up in the past.
I wasn't talking about the court. I was talking about society. Can I put a plug in for my conciliation program? Or I'm enthusiastic.
Absolutely.
Last time I was here, Councilor Iannella asked me about the conciliation program. You talk about diversity. The very premise of conciliation is that it applies to a diverse population with diverse problems and diverse backgrounds, and it's tuned to do that. Conciliators are trained to do that. More and more people from all parts of society are becoming involved as conciliators. It's an excellent way to make the court more diverse more quickly. And I promise you, I don't know if Michael will back me up, and I don't mean to be taking his time or your time, but it's an opportunity to get farther faster because there are more lawyers than there are judges who will conciliate cases. That's a fact. And people get heard at a conciliation process. Good conciliation, they get heard.
All right, I appreciate you answering my questions.
I hope I haven't bored you.
Not at all.
All right.
Thank you.
Yeah, just
Okay, Representative.
question. I remember you from before. On the conciliations, I've only done one divorce in my many, many years as a lawyer.
You're lucky, Counselor.
Thank you. Conciliators in the probate court, who appoints them?
They're not appointed. They are volunteers. They're not paid. They volunteer and they take a training course, which is what I do. And after they train, then they can become a conciliator and start hearing cases.
What does that mean, start hearing cases?
Excuse me, hearing is the wrong word. They can start participating in cases and have cases assigned to them so that they can get them resolved.
So
They're not appointed, they are just
is
volunteers.
that in every case the conciliator is appointed?
When you say appointed, I might be
Is
misunderstanding you.
volunteering or what?
They volunteer and they are, and what's your question? I'm sorry.
So in other words, Mr. and Mrs. Jones are divorced. At what, first of all, what stage is the conciliator involved in?
It depends upon the judge. Many judges wait to the pretrial status in a probate court matter. Some of them get ahead of it and will appoint a
Okay, let's assume
conciliator
at the
sooner.
pretrial.
I'm sorry?
Let's assume at the pretrial.
Yes,
To either party, can they say, no, I don't want a conciliator?
that's a controversial question. As I read the rules, I think if a judge wants to send a case to conciliation, they're hard pressed not to. Some people think that both parties must agree to go. It's a controversy.
Okay, I didn't mean to have a controversial question. Are most of the people, when a judge says we want to conciliate, are these people who are pro se, or are these people who are represented by attorneys?
Both.
Both. So now, okay, A and B come before the court, say the pretrial, and a conciliated judge says, let's have a conciliator Keller involved in this case. Is that something that this volunteer conciliated talks to him outside for like an hour, or is involved for like 20 hours on the case?
They're mandated to do 2 hours. It's a review of the case. Most conciliators spend 6 to 12 hours on a voluntary basis. And it is without discrimination as to who the parties are, whether they're wealthy or poor, whether they're pro se or represented. It's very democratic in its application.
To me, it's hard to believe that both parties have an attorney, you know, people who know what they're doing. All of a sudden, this conciliator comes. To me, it's hard pressed to believe that a conciliator can resolve the case, unlike, say, going to mediation, which may take 2, 3, 4, 5, different visits. But you're telling me it happens?
80%, I think the statistic is, depending upon the county, 70 to 80% of cases settle at the conciliation. And frequently it makes anything that the other 20% of the cases frequently actually resolved before trial. The conciliation has prompted the discussion and.
Yeah.
Ed,
Hold on.
Sure.
Excuse me, I'm going to call on all councilors to, are you?
No, I'm not finished.
I know, that's what I'm saying. Councilor Ianella has not finished, and when I do, I will open it up to anyone, any councilor who wants to ask questions of the witness. Will
So
you
wait a minute.
continue?
Wait a minute. You're saying that you got 2 able lawyers. Now, let's really say you got 2 high-priced lawyers. Some of these lawyers, I know what they charge, $1,500 an hour, $1,000 an hour, and upwards. And all of a sudden, this volunteer conciliator is going to meet with someone for 2 hours, 6 hours, and 80% of the time, it's going to resolve because of the conciliator. You're a great attorney, I'm sure. That's like impossible for me to believe. I do personal injury exclusive. Is that what you're telling me?
In the probate, that's what I'm telling you, in the probate court. It's less applied in the Superior Court, more applied in the District Court, but they're expanding that. I was just talking to the judge, retired judge from the Superior Court. They're trying to expand the program. Tort actions, trials of that nature are sometimes have their own characteristics. But the probate court, a spouse to spouse, an estate with heirs, a definite number of heirs as a defined group, it works very well, Counselor. It really
I'm
does.
sure it does, but help me out. You do a lot of divorce. I'm going to ask Mr. Anderson the same question. You do a lot of divorce. Now you have that 4-way meeting before the pretrial, and that can last several hours.
It can.
You, an able lawyer like you're going against Anderson, another able lawyer. You can't resolve. But all of a sudden, this volunteer lawyer comes in, this conciliator. What is that conciliator doing that you 2 guys couldn't do? In other words, this is just me. Are they like just trying to, what's the first thing that comes to mind? I'm sure this is not applied to you and I don't want to think it. Are they just trying to jack up the bill? I mean, like, I don't understand how this magical conciliator can resolve 80% of the cases where 2 able lawyers cannot.
I believe that most lawyers want to resolve their case. They want to. They want to represent their client zealously and do the best possible job they can for a client. A conciliator doesn't represent anybody. They're neutral. They're there to listen to the case, to the facts of the case, to the positions of the parties, and they don't take a position. If they take a position, they're not neutral anymore, are they? So they stay neutral, and they assess and they advise and they guide towards a resolution. The other thing that a conciliator can do is, and people are quick to do this, clients are quick to do this, clients will confide in a conciliator as to what the real issue is, what they need to be satisfied to get their case resolved, whether it's an estate, whether it's a divorce, whatever. Custody cases are the toughest, but they get an opportunity to vet, to be heard, as Counselor Kennedy points out, and they get it's almost like a relief for them. And then people settle down and they can talk about the substance of resolving their cases.
My last question.
I promise you, it is an excellent system. I'm sorry, Michael, I don't know why.
My last question, then I'll get more into Mr. Anderson. These conciliations, are they in the hallway? Are they like scheduled now? Volunteer John Smith is appointed conciliator, and okay, we'll meet at some location on August 15th at my office, at the conciliator's office, or is it in the hallway of the courthouse?
It varies depending upon the county and the way they apply the program. In Middlesex and Essex County, generally speaking, they are done in the office of an attorney.
At a later date, obviously.
At a date convenient for everybody, in the afternoon, or it starts in the morning. It's scheduled, and in my office, everybody gets a room. There's a central room that we can convene, and it's very good. There are blitz programs. Essex has tried a blitz program where they take in a half a dozen or some number of conciliators, and they will be assigned cases directly from the bench, given 45 minutes or an hour and a half to work and see what can be done. And that's been successful as well. Usually the cases that are more complex, you need more time, and it's nice to have your own office as opposed to a room at the courthouse.
Okay, thank you. Just again, I don't know, you explained it very well. I'm just thinking while I'm talking, yeah, it's a custody issue. We got a guardian ad litem, we got attorney affairs, we got alimony issues, we got visitation, and I appreciate it. All of a sudden, this magical conciliator is going to resolve the case. I'm glad it worked. I don't know enough about it, but I do appreciate it.
That I think that one of the biggest problems to the movement, the progress of the process, is people are sometimes skeptical. They don't understand it. All I can tell you is that I've been on the other side, and it works. Right?
That's good. I appreciate it. Thank you for seeing me.
Nice to see you again.
Thank you. Any other councilors have any questions? Councilor Juvenile.
You have convinced me. I know your reputation, stellar one, very honest.
Thank you.
You have convinced me of the problem we have and how to solve it.
Wonderful.
We don't need more judges. We need less judges. We need more conciliators. If they have the magic touch, then why are we even having people go to a judge in the first place?
Well, I think that I would not quite agree with that. I think you have to understand that a conciliator is a volunteer.
Yeah, that's even better. We don't have to pay them.
That's for sure. But they don't have, as Councilor Kennedy says, they have no judicial authority. So that if you really hit a bump in the road or something that's very difficult, a judge can make a decision. A judge is essential to our society. Instead of 6 guns, we have judges and trials now.
I'm being somewhat.
All right.
But not all facetious. I get the bump in the road. But why isn't everybody, or should everybody be mandated to go to a conciliator right after they file their application for divorce?
It's allowed. It's not used that way, but it can be used that way.
Because obviously, if I'm a client getting divorced, and I have a lawyer, you're representing the woman I'm getting divorced from. I don't trust her or you, right? She doesn't trust me or my lawyer. So that's probably one reason why lawyers can't do this work. It's a shame, but it seems to be should. And it's kind of funny because last night I watched a movie that I hadn't seen in years, The War of the Roses. And the lawyer, Danny DeVito, was telling the story about what happened to his client. And he brought up a lot of good points about craziness that goes on. You probably had cases where they get crazy.
I have.
And I know it's a lot of emotion, whatever else goes into it. Much like restraining orders in our court system. You ever done a restraining order?
Yes.
So I sit in the court sometimes and I see two people standing before a judge. And they are just kicking the holy hell out of each other in front of a courtroom full of people that they don't even know. I say, at one time, they said nice, loving words to each other. They hugged each other. They were crazy about each other. Now here they are strangers, saying the worst things they can say. So I advocate we need this, special courts. We need a love court. People can go to and love again, knock out holding hands. Maybe the conciliators that you train should be in those courts. But I'm a little bit serious in the fact that 70 or 80% conciliators, and I believe you, resolve the cases. Why are they even going before a court other than get the blessing at the end?
They certainly get that. That's fundamental to the way the process. But keep in mind, the judge is the ultimate arbiter of disputes, and the conciliator can't do that.
And in some cases, because you talk about good judges, that's what we all try to do up here, is to figure out who's going to be a good judge. But we've learned that people come here and they say whatever they think we want to hear. And then when they get a robe on, they turn into a terror on the bench. And I'm sure you could cite some names of judges, which I won't ask you, the Middlesex probate court, who were just awful. Awful. If you come before that judge, you probably go, oh boy. Right?
I can tell you one thing, Michael Anderson is not that kind of judge.
No, I'm not talking about Michael. I know about Michael, someone that I really respect. But you know what I'm talking about.
I know exactly what you're talking about. I cringe though, Counselor. Lawyers who conciliate, they're volunteers.
Let me ask you, let me interrupt you and ask you. If
Sure.
I'm getting divorced, and they say, okay, the judge said, let's send you to a conciliator. Do I have to pay for that?
I'm sorry, I didn't hear
The clients have to pay for the conciliation. Is there a fee for that?
There's in the last approximate year, maybe a little more, there is an administrative fee of $50 per person, or per side, I think, for administrative fees that goes to the bar association. There's a process of tracking the cases and so forth and so on. And most bar associations get stuck with that, so to speak, get stuck with that responsibility. So in the last short history, they've been instituted. It's $100 in a divorce. It's relatively minor, but the administrative costs, administrative time is probably difficult. They track the case. It doesn't get lost in a black hole.
For $100, I would suggest to people not taking away the fees that lawyers get. I would make mine living. But I would think two people getting divorced would be better off filing for divorce and immediately going to a counselor, one of these counselors. 70–80% of them are going to solve their case before they do another thing, right?
Those are the statistics.
Do you think the people that go before an arbitrator, conciliator, the fact that they are neutral, they confide in and they trust more than the lawyers on each side?
I don't know that they trust the conciliator more than their lawyer, but I think you do bond. I think the conciliator does a bond with both sides and gains their confidence, good conciliator gains their confidence that what they're hearing is correct and they're getting good guidance how to resolve their case.
Let me ask you another issue about probate court. You've got many years involved in probate court, divorces, correct?
Yes.
I'm always a little bit mystified and intrigued by this, what they call earning capacity. You ever hear that?
Yes.
What is it?
Well, in the context of a divorce, is that what you're asking me? A judge, or there's an opportunity to assess whether a person's income is commensurate with their talents, abilities, and there's something called RIDIS. It's rapidly disappearing income syndrome. And in divorce, people are not likely to want to have their best economic year because a lot of support, alimony, and so forth is dependent upon a formula, which is dependent upon the gross income of the person. So that some people slack off on a voluntary, they try to earn less money. So identifying what their income is part of the process.
Okay, but say you're a judge. How do you work this thing as far as that?
I'm involved in a conciliation. When I leave here, I'm going to do exactly that this afternoon. It is by instinct. It's by how the facts will be presented to a judge. It's by circumstances of the case.
Okay, well, do you take into account what each side is making for way of income?
Yes.
Well, what if the case happens that the woman's making $1 million, and the husband, who has a college degree, master's degree, isn't working? He says, I need that.
I've conciliated that case.
What do you do?
The secret to the case, Counselor, is there real resistance to paying alimony? We're supposed to be gender neutral. Academically, we are gender neutral. That isn't always the way a case plays out in the probate court. You have to find out if there's a specific case, exactly what the issues are, what the hesitation is, or what the goals are, whether they're realistic or unrealistic. Wage earners today, both sexes are generally larger wage earners than they were when I started to practice law. Both couples are usually working, many times are working in cases. And there's more income involved in these cases. And either client can try to manipulate their income, which will be hopefully Michael Anderson's job to try to sort it out. You do it, I think, and maybe it's a question good for him, is instinct and facts and history. I think history is also very important. And when I'm being a little vague, the history of what the income has been, the history of what the work has been, the history of the roles. In your specific example, if that master's degree person has never consistently worked outside of the house per se, man or woman, then that's the history to the case. Alimony may be very, very appropriate in that case, regardless of the emotions or whatever.
Well, if you give alimony in that kind of a case, you take into consideration the earning capacity of the other one who isn't.
Yes.
You assign a figure to it.
You can, depending upon the evidence, the quest, you try to determine what would be attributable to that person on a fair basis. And you haven't told me why that person isn't working. And again, historically, they may never work. They may have the case that I've said that I've actually done that case. There was some question as to that professor's, he had a brain injury, and there was some question whether he could continue to work after the injury. So it's fact driven. It's circumstance driven.
My example is something different, I suppose, in most cases. I would assume most cases are that husband is working, has worked throughout the marriage. Wife, after the children had grown up, if they had any children, went back to work, worked in different jobs. retail jobs and so forth over a period of time. And now the divorce comes up. Do you assign some earning capacity to the woman who stopped working retail? Let's say 5 years before the divorce, but is still in good health.
You've identified an important issue, and an issue that a judge has to struggle with, or a conciliator, as you've asked, has to struggle with. And it takes a lot of common sense to deal with it. Sometimes you go completely on instinct after meeting the person. Sometimes people claim a reason and there's no substantiation for it. It's why you need Council Kennedy left the room. It's why you need good judges. You need judges who have the ability to weigh out and understand, not preemptively, not arrogantly, not in a dictatorial fashion, but that try to understand the facts and the problems of the people and what needs to be done to get the case, to help make people's lives better. That's probate court does that to a large extent. It brings, you saw the War of the Roses. I think, I haven't seen that movie in years, but I think one of the spouses, they died, didn't they, or something like that?
Died.
Yeah, they both died. That's not usually the case, but there is.
Usually.
I'm being facetious, Counselor. But there are people if they can get through the divorce, they go back to their lives. And there's peace and comfort that can be that a probate court judge or the process can provide.
I like judges, but I got to tell you, after listening to you, I think we ought to probably think about that.
And I'm not going to take any more time. One of the
that sit in our courtroom, they would get rid of a lot of this backlog. Don't you think?
It's true. I think that one of the controversies is, should a conciliator, they're mandated to give a couple of hours. There are people that, like me, that give an endless amount of time. The case I'm doing this afternoon, I probably put 40 or 50 hours into already. That's over and above what can be done. But you've got to be kind to conciliators. These are people who are volunteering, trying to help. And they're taking that, if they're not getting paid for that time, which is admirable and generous. But most people have to make a living. Most people can't afford to endlessly volunteer.
But doesn't the court have something? Yeah. You had to go down and meet with, was it one of the probation officers?
That process is, yes, well, it depends upon the judge. That avenue is still available. There are probation officers. Excuse me, different judges use it in different ways.
And they would basically tell you their opinion.
I think that's probably true.
They still use
I think they do. Not necessarily at the pretrial, but at various stages along the way. They're great people, generally speaking. Family service people are there to try to help resolve whatever the issue is. Excuse me, whatever the issue is for the day.
Well, you think program outlined here, probate court probably should have paid state employees that are neutral, trained in this conciliation, and are in court. Well, that's their job. They make a living.
Again, that's above my pay grade.
Just an opinion. I'll say you conciliators, you gotta make the opinion here. Why wouldn't it be good?
I can't say it isn't good. I think you have to think about the structure. I think that the one thing about conciliators is that not only have they taken the training, but they are lawyers. So they're familiar usually with the system, usually with the judges, and certainly with the law, and usually are experienced in the facts and so forth. And they can blend that together to help foster a resolution. I don't think that you could, I suppose, find staff and train staff and try to do that. I suppose in theory you could do
You have
that.
to be a lawyer to be a conciliator?
Yes. That's the SJC standard. Mediators don't have to be lawyers. Arbiters don't have to be lawyers. Conciliators have to be lawyers. Conciliation program is a quasi-judicial. It's within the context of the courts.
Hey, great. Thank you.
I hope I haven't talked too long. I hope I haven't.
Councilor Iannella has asked him.
yeah, just to follow, I don't think he answered this question. If he did, I couldn't hear it. Same hypothetical, exactly. Well, I couldn't hear him that well. One spouse is making $1 million. Spouse over here, perfectly healthy, making nothing. Hasn't worked in 15 years because this spouse here is making $1 million. The only reason. College degree. You were signing an earning capacity. No kids.
Again, I'm not a judge.
No, but
So I'm not a judge. I think that.
I'm going to ask Mr. Anderson, what would you do? What happens in those situations?
Well, I'll give you my answer, and I doubt that Michael is much different than mine. I don't say that arrogantly. I think he's an experienced attorney. It's fact-driven, counselor.
I gave you my fact.
Well, the fact that if it is a long-standing marriage, and if traditionally that person who wasn't earning had traditionally not earned, and their role was not the earner of the family, but the person being supported in the family. And again, depending upon the length of the marriage, if they've been out of the job market for 20 years, that person may have a degree, but may not be that employable. Their degree may be stale. What they're trained for may no longer be required by society. So it's again fact-driven.
I totally agree. And under that situation, what do you think a judge would assign an earning? I agree with everything you just said. Do they have any earning capacity? I understand everything you just said. And if so, what? Then I'll tell you what other judges have said in the past. Because I asked that question a lot.
They're economic experts, depending upon how much you can
tough
devote to a case. There are people who can estimate what this person could or couldn't do and what their salary may be.
So whatever he said, retail hasn't worked.
The way our system is, and I think that's what you're asking me, when people come like this in front of a judge, it is absolutely the presentation, the facts and circumstances, and the intuition of a good judge.
Okay, you didn't answer. You didn't answer my question at all, which I don't appreciate. Huh? You didn't answer it at all.
Oh, well, let me try to understand.
Make it simple. We're not. Are you going to assign him $5 an hour, $50 a week, $2,000 a week? That's a tough question. You're the expert. I don't do divorces. He asked you a question about earning capacity. If you had said, I've never heard of it, I get it. Hold on. We get it. Hypothetical, long-term marriage, has a college degree. Okay, is it worth what? Minimum wage? Is it worth $200, $5,000? Just a college degree, whatever he said, retail, long-term marriage, just say even no kids. Are you gonna assign an earning capacity? This guy's making $1 million.
More likely than not, if you want a yes or no answer, more likely than not, yes.
Okay, and what do you base the earning capacity under? And then I'll be upfront with both of you. I will tell you what judges in the past who've come before me have answered that question.
If there are nominees who come in before you, they may well be telling you what you want to hear, because the fact of the matter is, there isn't a good judge who can answer that in advance. It's going to be, and I'm sorry to be evasive, and you said I haven't answered the question. You have it is circumstantial, and it's what drives it. You haven't given me enough facts. You haven't told me why. You've told me the person hasn't worked traditionally. That's what you told me. You didn't tell me what his degree is. You didn't tell me if he's
college degree, political science.
In political science. Has he taught?
No,
has he or she not taught?
Just retail.
Retail. Then the experience of that person is in the retail industry, and you might, as a judge, try to assess what that person could earn if they had a history of doing it. I think that there has to be more inquiry.
Well, what else would you want to know?
I would want to know, I've already said some of the things I'd want to know. I'd want to know the predisposition. Why doesn't the person?
I don't think the husband or the spouse been supporting me for all these years. He makes $1 million. What do I want to work for? I like relaxing.
And that person may be a little bit in trouble because there's probably a propensity. I think there'd be a propensity to attribute some amount of money to the calculation of what the support would be to that person. So the calculation could be.
Right. Well, I'm going to tell you what other people.
I'd be curious.
Yeah, because you haven't, with all due respect, you haven't told me anything.
I'm sorry.
You haven't told me anything. If I was a teacher, and I don't mean to be arrogant, I could be a failing grade on that.
The story of my life goes.
Most people who come before us, they want to know, first of all, the educational back, everything I told you, perfect. Have they worked? Why haven't they worked? Are they sick? Are they this? my hypothetical, everyone's feeling great. I didn't work because he's making $1 million. No other reason. I used to work before I got married, for the first 3-4 years. We have no kids. He's making $1 million. I don't want to work. I want to go play golf. I want to go here. I want to go vacation. I don't want to work. Here's what they say to other people. At a bare minimum, high school dropout, they give minimum wage. You didn't say anything like that. With all due respect to Mr. Anderson, I asked him this question. I wasn't even bringing this up if Mr. Jubenville didn't. He answered the questions that most nominees have answered. He didn't answer much. Minimum wage, high school dropout, they give minimum wage. Agree with that? Under my same hypos. Most of the people, and I asked most of them, that's what they said.
It's a crisp answer. I don't agree with it.
You don't agree. Most people say if it's a 2-year college, they give a little more. If it's a 4-year college, excuse me, and they have some type of work history, let's say retail, let's say, oh gosh, I don't know, was a real estate broker. I'm trying to think of my sisters, what do they do? They would depend on what did they make at one point. That's what they would base it on. Most judges say whether one spouse is making $1 million, other spouse is making 100,000. It does, and Mr. Anderson, to his credit or discredit, we're going to look at it, said it does not make a difference. Do you agree with that?
Of course it makes a difference.
Okay, he said most of the people on the earning capacity. So if someone's making $1 million, does it make a difference when you assign an earning capacity what the earning spouse is making?
You're touching upon the requirements of the standards of Section 34, which is part of the law. And what some of the things just recited are, in fact, considerations that a judge must do. They look at health, they look at education, they look at work history, they look at their ability to earn money, they look at inheritances, they look at potential. And those are very subjective and individual kinds of subjects that can vary from one counselor to the other, one person to another. So again, I'm sorry if I'm not responding, but to me, it's specific. I want to know more facts. You've got to give me more facts about what to do. To impose upon somebody a minimum standard is sort of a social and legal standard, right? If you work, you have to earn the minimum standard. Can somebody live on the minimum wage? Again, that's above my pay grade too, but I think you're hard pressed at $12 an hour to make a living and sustain yourself for a family.
Who said that? I'm saying.
So the standard of applying a minimum standard is, in my opinion, probably unrealistic in your fact pattern.
Well, first of all, you didn't, and then I'm not going to, then I'll go to the standards again. I don't think you understood me. I said, if the earning spouse is making $1 million.
I got that.
And now the non-working spouse, the judge assigns an earning capacity of $25,000 a year. My understanding from talking to other judges will base the alimony on $1 million minus $25,000.
That's the formula. That's what they have to do.
Saying. So
yes.
It's not like I'm saying this person doesn't live on minimum wage when the guy's making $1 million. Of course not. If someone's making $1 million, you got a high. Everyone's got an earning capacity if there's no health issue. Okay, if there's no health issue, they have in juveniles hypothetical college degree, retail background. Even if you assign a minimum wage, even if you assign whatever, 15,000, even 20,000, 25,000, and I know you're not the nominee. If you're the nominee, I'm really, really pressured. And with due respect, all due respect to Mr. Anderson, he answers the question. And most of the people, everyone who's come before us has answered the question. Something, I'd assign this. Again, you're not the nominee, and I appreciate it, but you did not answer my question even close to answer. I mean, ask me any fact pattern. I don't want to waste everyone's time, but at what point would you assign someone an earning capacity?
And again, you stop this discussion anytime that you want. The fact of the matter is, let me give you a typical example. When I started to practice law, frequently there was a man who was the wage earner in a family, and there was a wife who was a homemaker. That was the beginning of my practice. Today it's a little different. Both parties frequently work in some capacity. So it's not that hard because they'll come in front of you and they'll tell you what they're doing. All right. But you're asking me the extreme situation where one person hasn't worked and one does. And you said,
Just like my present wife, who I love, has never worked a day in her life.
all right, so now the
So when
question,
you say extreme, I take offense to that.
I'm sorry.
Extreme. My wife doesn't work now. She doesn't have to work. I'm fortunate enough that she does, and she's a household manager. She does a phenomenal job. And that's what she wants, and that's what we both agreed on. I don't call it an extreme situation. So,
I'm sorry, when I say extreme, it's a vast difference. One's a wage earner, one isn't. I don't mean it as a standard. Certainly don't mean to insult your wife, because that person as a homemaker does have a value, has contributed to this partnership, and it has to be considered. In the same way, that's the reason I gave that example, is because it was something similar to yours, but I think that it's easier to identify with that homemaker, with that woman who has that mother and wife who's contributed to the marriage. And the question that you're really asking is what's fair, what's appropriate, and how to do it. That's what you're asking, I think. And my answer is apparently unacceptable, but it's fact-driven, and it's what I think would be appropriate. Would I let that person live? If the person was earning $1 million, would I let that person live and attribute? Do you realize that if I deducted $25,000 from $1 million, it would have no effect on the formula at all?
totally agree.
None at
I
all.
totally agree. But why don't you say something? Why don't you start something?
Okay.
That's what you got, right. But I'll follow up with Mr. Anderson.
His wife is also a very, very nice person.
I don't doubt that for a moment.
She's a sweet, very nice person.
What do you
I like her much better than him.
Uh,
I agree.
Have you completed your
Yes,
question?
thank you so
Okay.
much.
I just wanted to say that the witness had been questioned 1 hour. 1 hour, okay?
I'm not applying for
So,
anything,
yeah,
ladies and
so I'm
gentlemen.
just saying that I welcome any, I welcome all of the questions from counselors, but I just want to be mindful of that the Lieutenant Governor has an assembly, and I hope that she will postpone it a little bit, because I don't think we're going to meet that threshold of 1 o'clock. And I want to hear from the nominee, and I want people to feel free, all the councils here, to question. So I am going to ask if the Lieutenant Governor would come in a little late from 1 o'clock, because it's after 12 now, and we haven't questioned the nominee. So, but I do want to thank the staff for allowing me to preside over the State House, and I do want to thank the councils for coming in, and we're doing our social distancing, and for people who have never, seen it or heard it. We are 7 councilors, and I have 3 of my colleagues here. And thank you, Councilor Iannella, Councilor Kennedy, and Councilor Iannella. And we have 2 remote, 2 councilors, Councilor Hurley and Councilor Duff. And so with that, I want to open it up to our remote councilors. Have you any questions of the witness? And let me just state for people who have never come or never known, the reason that the Governor's Council established having witnesses, that is so the councilors can be advised by this witness what they know about the nominee, and to advise the councilors all that they know and in their recommendation. So with that, Councilor Hurley, Councilor Duff, if you have any questions, I wanted to open it to you.
I don't have any questions. What
Councilor Hurley.
about the candidate, I heard in the first 10 minutes. The rest of it, having been a practitioner in the probate court, is mostly subject to a judge's discretion. There are 20834 factors that come into play. So it's not, I make $1 million, my spouse worked. There's a lot more, and suffice it to say, there's volumes that have been considered court and the appeal court on a lot of these issues. So I thank the witness and not only for coming today, but also for your work with Conciliation. Because a lot of times what people hear on opposite is somebody who's got in the game and basically point out the reality of a situation. So thank you, sir.
Thank you, Councilor Early. Thank you for your kind comments. Thank you.
Is that a question for the witness for Attorney Negro?
Counselor Duff?
No.
Okay, thank you. Well, for me, you know, I just want to know, how many years have you known the nominee?
I would say actively between 5 and 10 years or so.
Okay.
Quite some time.
So were you an opposing attorney in court?
How I first met
Okay.
Michael.
How many times have you been an opposing attorney? With
In the near past, twice.
Okay. I don't need to know the names, but can you tell me about that case and if you won or did Attorney Anderson win those two cases? And the other thing is, when you came out, what adjective would you use for Attorney Anderson with his demeanor?
Dignity is if I had to pick one word, it's dignity, and the second word would be intelligence and understanding of the law. Those would be my first two comments.
Yes, it is.
You asked me about the two cases in the near past. One I referenced in my opening was a couple that had gone to a mediator, had an agreement. It was a binding contract. It's called a surviving agreement. I don't know if you're familiar with that. And Michael's client wanted to upset the agreement. And they are difficult cases. It is unpredictable what a judge will do. And what I found in Michael was that he was direct.
Okay, thank you very much. You know, I appreciate you coming. It means a lot, especially being an opposing attorney. So what was the adjective that you attributed to?
The first one I used was dignity, the first thing. The second thing that I said was he's intelligent, insightful, and knowledgeable about the law. He has a real ability to interact with people on a positive basis. And Counselor, in the probate court, I think it was mentioned here, there's a lot of vitriol, there's a lot of anger. It seems to me that lawyers are angry with lawyers, judges are angry with judges and lawyers, and it's a difficult place to do business. Michael brought real temperance and real a quiet ability to solve the case, which allowed for discussion, which allowed for resolution. There was an allegation, there was no vitriol in the man's behavior.
That's good, thank you. I think that you know, we should be moving along because we are an hour and 11 minutes into this, and I would like to get to our nominee. Before I do that, is there anyone in opposition? We haven't got a letter or anything in our office. So having no opposition, I will now, it will be, thank you for your patience, and I will open it up to our nominee, Michael Anderson. Welcome.
Thank you very much.
Councilor Devaney, may I leave?
Yes, you may. Thank you very much. We
Thank you.
really appreciate it. And you did your due duty today. You really did. Thank you.
Thank you. Thank you very much.
I'm sorry. You know what I forgot? I said that I would read the letters of there were two people who really wanted to come, but because of their schedule. And I think, you know, in respect to those people, I want to read it. And one of them is, let me see, Robert Ferrullo, who is a former police chief in Leuven. And he has known you, you know, for 20 years. You've been a coach of his children. You served on the city council with him. When he was a chief, you worked with city issues and neighborhood issues. And you always had the ability, passionate ability to discern right from wrong, regardless of the popularity of the decision. And he is urging the council to support your nomination. And he said, you are a leader among peers in the legal profession and an innovative trendsetter as a community leader on the Woburn City Council. And the other person who was going to speak on your behalf was retired Judge Randy Kaplan. And she said it was great pleasure that I accepted Michael's invitation to speak as a witness on his behalf at his Governor's Council hearing, especially since, if approved, he will be filling my vacancy on the Probate and Family Court bench. I am very sorry that I am unable to attend tomorrow's hearing, but I ask that you accept this letter in lieu of my testimony and my apology for not being able to appear in person. I am personally and professionally grateful that Michael is being considered to fill the current Probate and Family Court vacancy. It is critical to the court system to have candidates like Michael, who I believe displays all the qualities that are important for a candidate for a judgeship. I believe that a judge needs to have a comprehensive knowledge of the law, including a thorough understanding of the rules of evidence, empathy, a balanced temperament, and good organizational skills. I believe that Michael has all of these qualities. I have known Michael for 25 years, first in my capacity as an attorney, and then as an advocate in my court. In the cases that I had with him as an opposing attorney, he was always professional and reasonable through remaining an advocate for his clients. During my 18 years on the bench, Michael appeared before me on multiple occasions on a variety of contested and uncontested matters. In court, Michael was always prepared, respectful, and even-tempered. He was always a pleasure to have him in my courtroom. He was able to resolve the majority of his cases, obtaining fair outcomes for his clients. A number of years ago, Michael tried a very complicated where his client, the father, was accused of domestic violence, was arrested, and then subjected to a 209A restraining order. Michael was able to calmly, methodically disprove all of the allegations made against his client and obtain a good resolution for his client. I believe that the Probate and Family Court is one of the most important courts in the Commonwealth. Most citizens of this state will pass through its doors for some family matter, and all of the issues have a profound impact on children, families, and elderly population, and persons suffering from mental issues. Judges are asked daily to make decisions with limited resource. Therefore, a judge must have a wealth of knowledge about those matters in order to make swift yet reasoned decisions. A judge also needs to have compassion to make these complicated decisions. I believe that Michael has these qualities. Michael's skills and temperament are even more important during these challenging times that the court system and our society are facing. It is important that a judge also have an understanding of what practitioners and litigants are experiencing daily during this current pandemic. It is more important now than ever that judges encourage respect for the judicial system. It will be challenging for all judges to deal with the tremendous backlog in being able to dispense justice with the concerns regarding this pandemic. I believe that Michael will be able to manage the challenges on the bench. In addition to his skills, he has successfully managed his own practice for many years while also raising 5 children. I was so happy when Michael told me that he was applying for this judgeship. It has become more and more difficult to get candidates to apply with Michael's level of experience. It is so important that experienced and compassionate people be appointed to the bench whose litigants can rely upon to apply the law and treat them with the respect they deserve. Most people passing through the probate and family court are at the most vulnerable times in their life and have to believe that the system will be fair. I know that many of my former colleagues spoke very highly of Michael's skills as an attorney and were thrilled when he was nominated for this position. Michael also developed good relationships over the years with court staff and understands the need for a good working relationship with all members of the court system. I believe that Michael has all of the qualities that make for an excellent judge, and I wholly endorse his nomination as the next Associate Justice of the Probate and Family Court. I want to thank you all for your time and effort ensuring that our courts are staffed with the best possible judges. Very truly yours, Honorable Randy Kaplan, retired. I'll tell you, I've been here 21 years, and this is an outstanding letter of recommendation. And not only that, you know, she's retired and she is endorsing you to replace her. That's quite a recommendation. So she was unable to, as she has said, she was unable to make it. The third letter is from Representative Kaplan. Is it? No, I'm sorry, Representative Cataldo. Okay, and he wrote a letter saying that he has known you for 29 years. He has been in practice that long, and he talks about recommending you without reservation, and that you've gone to college together and you've been friends all these years and from law school, and how you have specialized in domestic relations, and that you've had your own practice for 20 years, and that your reputation is outstanding domestic relations trial lawyer. And he has not hesitate to refer clients to you along the way, and everyone has been very proud. And he's your ethical, honest practitioner who does the Massachusetts bar proud. In all three communities in which we have in common, college, law school, members of the Massachusetts bar, his reputation is the same: smart, conscientious, affable, honest. While Mike earned and maintained his excellent reputation, he continued to be, and is a loving husband and father to 5 children. His background and solid foundation give him great insight and compassion to the hardships and difficulties of raising a family. It is without doubt that Mike has the wisdom and compassion to preside over highly volatile and contentious proceedings with an even temperament and good disposition. I strongly urge you to affirm Mike as an Associate Justice of the Probate and Family Court. Very truly yours, Joseph P. Contaldo. So those letters will be put in the record. But in respect to them, I wanted that on the record. So now it's your turn to make your presentation.
Well, thank you very much, counselors, for your time. Thank you for being here. I've prepared some thoughts that I'd like to state, and I know my short and sweet is what I was told, and short and sweet is what I will try to be, but I wanted to convey a lot of information. First, I'd like to thank Governor Baker and Lieutenant Governor Polito, together with their legal counsel, Bob Ross, for meeting with me and for ultimately having the faith in me to warrant a nomination to be an Associate Justice of the Probate and Family Court. It's my goal to make them, and you, if you agree, proud to have put me in such a position. I especially want to thank all of you for continuing business safely during the pandemic, and wish all of us that have been affected the best going forward. I also want to thank my Governor's Council member, Marilyn Petito Devaney, for hosting this hearing and for answering all of my questions over the last 2 weeks. The same goes for all of the members of the Governor's Council for taking the time to both speak with me and meet with me in advance of this hearing to give me the opportunity to introduce myself and answer any questions that you may have. I know you have many responsibilities, both as Governor's Council members and also in your private practice, professional lives. So I do appreciate your time, your advice, and your commitment. I'd like to thank the Judicial Nominating Commission for their service, and especially Lauren Green-Petrino, who has been exceptional. The process has been daunting. It's been very extensive. Just the thought of what you have to go through can be daunting. You can be comforted by the fact that I've experienced a process that requires a substantial amount of vetting with inquiries of judges and colleagues at every turn. Finally, I'd like to thank everyone who's spoken on my behalf, whether it was in the due diligence process or now before you. While there are many, I'd like to specifically thank retired Judge Randy Kaplan, whose position it is now that I am seeking to fill. If it weren't for her encouragement to apply, I might not be here. I regret that she had a personal emergency to prevent her from being here, but she was able to submit her words, which were very kind. Thank you to Attorney Jean Nigro, who is one of the family law's bar's most respected attorneys. His memory might be failing a little. It's definitely been more than 5 to 10 years, but of course, my own personal life, people ask me when something happened, I say a year ago, and I find out it was 5 or 10. We've litigated cases against one another over the years, and nevertheless, we're still able to talk to one another. It's critical for our courts to maintain collegiality, and Attorney Nigro sets an excellent example that I hope to foster from the bench. Attorneys Cataldo and Ferrulo, who is also our retired police chief, and Woburn, and a colleague of mine, were kind enough to submit letters. I appreciate that. I've known Joe since 1984. We've attended college together and law school. And Bob Ferrulo, I've known in many capacities as police chief, as a member on the city council, but also more proudly as parents of children the same age. I hope they both provided you with some perspective about who I am, not necessarily as a lawyer, but as a person. Seeking this position was not something that I decided to do on a whim, obviously. I've contemplated applying for a judicial position seriously for the last 10 to 15 years. Indeed, it's something that I've been in the back of my mind from the very first day I stepped onto Suffolk Law School's campus. About 10 years ago, I was around 43. I downloaded the application, and after reviewing it, decided I was not ready. Why? Obviously, that's a good question. Why were you not ready? Many factors, but the most important was we had 5 children between the ages of 7 and 12 at that point. And frankly, for my wife and I, family always comes first. And having the flexibility of being self-employed with my office in where we live was key, enabling me to ferry our kids around and attend all their activities, make sure their skates are sharpened, tied, and all those things. Another factor I considered was the criticisms we as practicing attorneys sometimes voice about appointments: too young, not experienced enough, and I didn't want to be that person that was too young or didn't have the experience, and right now I am not that person. The application process was very introspective. I had the opportunity to review all of my cases with the benefit of the computer system. I can look at almost everything I've done over the last 30 years, which is hard to believe, 30 years. But in being introspective, I realized that certainly I am ready. The importance of the law, which is a concept, but it's real and it affects us every day, has been drilled into me from the day I was born, practically. It's in my DNA. My maternal grandfather was a longtime district court judge in Marlborough. His wife, my grandmother, who lived until she was 101, and I was the favorite, I'm just saying, was no slouch either. She was the first female school committee member in Everett. And later an attorney who helped found with 2 of her friends, the first all-woman law firm, Curry, Moles, and Murdoch, which was located right around the corner on the 2nd floor of 6 Beacon Street. She was very proud of it. And not to be outdone, after raising 4 children, the day I went off to college was the day my mother went off to law school, nights. My father, he paid for it, 4 college educations for his children, and a wife in law school, and that didn't leave much. As my father summed up his investment strategy, I invested in education, a lot of education. Both of my parents are gone now. They would be beaming with pride. Seriously, that came out of nowhere. But they would be very proud, and I miss them. They raised me, my two brothers, and my sister with some basic concepts: work hard, value education, respect others, and that we were no better or worse than anyone else because of race or religion. And that also includes sexual orientation, as we welcome my brothers' husbands into our family. Hard work's been something I've embraced my entire life. My first love was sports, football, hockey, lacrosse in high school. Frankly, anything with a ball and a stick, and I loved it. At my size, you quickly learn that you better outwork and outsmart your competition. That's the same approach I've taken as a lawyer: hard work and work and work, and try to outthink the competition. And better, when you're going up against the larger firms, you better optimize the resources that you have. I've had the good fortune of working construction company for 5 summers between college and law school, which definitely made me know that I wanted to be pushing paper. It was hard, dirty work. The laborers all had different backgrounds. We routinely worked 10 to 12-hour days, Monday through Saturday. Summer vacation for a college kid and law school kid did not exist. But by the time I left, I met the most wonderful people that I had ever met, and I'd never meet them in college and law school. And to be sure, some of the grizzled vets were skeptical of the college kid at first, but the best way to fit in is to work hard, and that's what I did. And I'm still in touch with many of them, and I'd like to thank them if they're watching, or I will thank them personally for helping make me the person that I am. When I graduated law school, we were in the midst of a recession, yet I was lucky enough to be offered a position at the domestic relations firm that I was clerking at, McClellan and Zach. Jerry McClellan was a retired probate and family court judge. Alan Zach was a well-respected domestic relations attorney. And it was the experience and education of a lifetime as I was thrown into court the day after I was admitted to the bar. They never held me back. I had the good fortune of working on complex cases with and against some of the most preeminent lawyers and firms in Boston at the time. And again, they'd never held me back when perhaps they should have, but they had faith in me, and which I appreciate to this day. And I acknowledge what a great place it was to learn. You learn by doing. In 2000, with our third child on the way, I'm trying to be quick. I'm trying to cut this as we go. 2000, I went out on my own. We were due with our third child, Lydia. It was the best decision I could make. I've been self-employed for the last 20 years. There's no passing the buck when you're self-employed, and I'd have it no other way. I do not delegate. And with my 30 years of legal experience, together with my history of managing my own office, my city time, the city council agenda as president, and my home life, although my home life is probably governed by someone else, I'd still say I'm well situated with these skills to help to be a judge in the probate and family court. I'm here to assure you that if you approve my nomination, I will conscientiously apply the law to everyone who comes before me in a fair and equitable manner. This is critically important. Most people who have any interaction with a court will have that interaction with the probate and family court, whether it's dealing with an estate of a family member, a divorce, guardianship of a parent or a child. They ought to have a positive experience. It is, after all, part of their government, and it's unacceptable for people to come out of the courtroom, as indicated, and be like, I got short shrift. I didn't get heard. There is nothing worse than that feeling. And as attorneys, we sometimes get that feeling. I'll strive to make sure, even if I cannot provide the relief that's been requested, that the people before me know that I listened to what they had to say and will understand why I could not provide the relief they requested. I think we owe them that. To your question before, Attorney Iannella, Commissioner Iannella, why is the conciliation process so successful? Sometimes the attorneys and the parties, they get entrenched into a position. And you're talking to your client, you tell them, this is our position, but you shouldn't believe all the hype. This is what's going to happen. Well, now they're believing the hype and they're not necessarily believing you. Now you have a third party there who can tell you what their thoughts are. And why can't this happen from the court? It can. It's just how busy the courts are now. You don't always get those words, those pearls of wisdom from the judge. This is how I view the case. So this is often sometimes the first time you've had an independent party say, hey, this is where you're heading. I know this judge. With that, I'd like to, there's one person I haven't thanked, and that would be my wife for her support and my children. Without them, without my wife, really, and my family, I'd not be here today. They are the most important thing in my life. And I do appreciate your consideration, and I'd be happy to answer any questions that you have.
Thank you. Before I open it up, have you introduced your wife?
This is my wife, Attorney Margaret Pinkham, which I shouldn't say this in public, but I do call her.
Thank
My
you.
kids will tell you the same
Thank you.
thing. She's got the best cross-examination techniques.
Now I'll open it up to questions from the councilors. Sort of calling Joseph Ferrara, he is absent. I'm going to go to my remote colleagues. Councilor, let me start with Councilor Hurley. Questions for the nominee?
Judge, we
We're having
can't hear
trouble
you.
with the sound. Hold it, Mary.
Thank you very much. The nominee had quite a lengthy conversation about his application and his philosophy of practice in the probate court and what it would be as a judicial or as a court. I am satisfied that his qualification and understanding of the difficult that occurs in the court are going to serve him well as a probate court judge. When I was on the district court, we used to say that we saw the worst people at their very best in district court, and that in probate court, you often saw the best people at their worst. So I'm not sure if I'm still being heard. Am I?
Yes.
Okay. In any event, I would indicate that I am going to vote for this nominee. I think we need more people like him. I also agree with Councillor Kennedy that we need more women and more minorities. I would point out that the Chief Justice of the Probate Court before Judge Casey was Judge Ordonez, who was Hispanic. And I just hope that we continue to make strides in attracting nominees who are well qualified and also who are recognized for their minority status. So thank you very much, Mr. Anderson, and I wish you the best of luck on the bench.
Duff?
Yes, can you hear me?
Yes.
Yeah, thank you. I concur everything that Judge Hurley has just said, but I do want to ask the applicant, because I think this is an extremely difficult court to go into. And I know that you've mentioned your brother, but have you had any cases where you've had to assist or litigate parents or folks who are transgender?
I have not had the transgender case. I have not.
Okay. You know, I know that this is a very difficult issue for a lot of folks. And as I say many times, but it's a real issue. And I can imagine for families, especially if there's an issue that's in your court, it could be quite challenging. So I would ask you to do some outreach to some of the, support groups like Bagley and such, where you can learn more about youth, particularly who have struggles with some of their identity and learning who they are. I think it would serve you well on this court.
I will. Thank you.
Okay. I'm sorry, I have a feedback here. I saw where you went to college. Where did you go to high school?
I went to St. Mark's out in Southborough.
Oh, okay. all right. You know, one of the things I say to folks sometimes, and you've participated so much in the community. I think it's so important and so great. I think it's important for young people, students, particularly in public schools, but private schools as well, to see folks like you, and to have opportunities to interact, to see you in the courtroom, or to, you know, if you can go out and be a guest speaker or something. I think it's imperative. We're at a critical time in our country right now. And, you know, you're clearly a white guy. He can't help that. But there's a lot of folks that they're afraid. And, you know, even though your court is different than some of the others, I think all the outreach you can do is really needed and meaningful. And so I do ask you if you would commit to doing some of that sometime while, if you become a judge.
Absolutely. I love doing that. We do a government day in the city of Woburn where we have public high school kids come in and we talk to them and we take them around for a day. I love doing that. And if I have the benefit of having a judge next to my name, I will absolutely love doing that. I'd love to have kids come to the courtroom, see what's going on, learn the system. I think learning our local government and also the courts. People shouldn't be afraid of the courts. The courts are there to help them. And certainly the probate and family court is. Some people can be afraid of the district court for the wrong reasons, you know.
Now, I concur with that. I've brought judges to some high schools to speak, and the conversations with the students have been absolutely remarkable. And they're very, very curious. You know, even though you're in a little bit of a different court. So to switch a little bit, what would you feel has been the most challenging case that you've had to deal with as an attorney?
There's been several, but one of the most challenging, I've had several removal cases which were very difficult because the impact that could have. But the one that I will choose to speak about will be one where, which is in my paperwork, I believe, was where I represented a man who was a state police officer who, I don't know if I want to get too much into detail, but he was portrayed as a brute very early on in the case, and it was very, very convincingly, as the wife was a respected member of the legal profession. And so right from the get-go, my client, there was one child who had a special needs, and my client was very much the equal, if not the primary. And all of a sudden, he was squeezed out on temporary orders, threats, and when you're dealing with someone who's very credible, who has a Esquire next to their name, who submits numerous affidavits, it was very difficult to, over time, or difficult at first, to show all of the inconsistencies in the statements. And anyway, it was a very complicated case, a very long case. We had a 13-day trial. Judge Moriarty did a great job, by the way, in giving us, she didn't give us consecutive dates, but trying to get us dates. And we were able to show that this guy who was 6'6" and shaved head and barreled through doors was really a very tender father who deserved to have custody of his father. And it worked out great. And he was in a position to be able to foster, you know, he could have been very resentful and angry, the mother, and he's been able to foster a relationship between the child and the mother. Kid's in college now and he's doing wonderful. And that would be one of the ones. And then, of course, those removal cases are difficult. And I had a couple of those where, or at least one that I can think of at the present time, where we had guardian ad litem who did 2 reports, and both of them said that the mother should be able to take the child to out of state, which would have been devastating to my client. And we had to try the case and before Judge Keeney, and when she was in Middlesex, and she, you know, it's easy to just adopt the GAL report, and she didn't. She found that the child should stay in Massachusetts. The mother shouldn't be able to remove the child, and my client, who was a father. But don't get me wrong, I have just as many woman clients as father clients, but those are 2 difficult cases that really would have broke both of those persons, and both of them were able to foster a relationship, which is the most important thing. Which of the parents is still going to be able to foster a relationship after all the damage has been done in this litigation? Are they still going to be able to have a productive, healthy relationship to raise this child? And in both of those cases, that did come to fruition.
Yeah, and that, you know, I'm blessed that I come from an intact family, and had great contact with both sets of grandparents until my mid-20s. I was blessed to have them all. So I was raised in this big Irish, Italian, Catholic extended family, but so many are not and don't have the same blessings and opportunities. And then one of the things that I find disturbing is how many people, and I'm sure well, I'm going to ask you if you've witnessed it, because I shouldn't assume anything. They use the children as pawns in these cases. Do you find that to be more common than not, or?
I would say it's not more common than not, no, but it is common.
Yeah.
Maybe not common, but we do see it, unfortunately, because there's dollars and cents tied to time with the children, although with the new child support guidelines, we are getting away from that. And frankly, I have seen in the last several years, parents are much more cooperative or collaborative raising their children. So that when they do get a divorce, it's difficult for them to turn around and say, well, we haven't been, I've been solely responsible. But we still do see that where a parent tries to use the children. It's unacceptable.
Let me ask you this. In a case where a couple gets divorced and they put in the original agreement that at some point alimony, they're not getting alimony, no one on either side is getting alimony. But one parent is clearly working hard and, full-time plus, and pays child support and is responsible and everything. And the other parent really is doing a minimal amount of work with no effort to really get any more employment. What do you think about that parent revisiting the fact of saying, well, at a certain point now I want alimony? Because that seems grossly unfair to me.
Well, they are entitled to. They're entitled to seek it, but I think you have to take that into consideration. They've known that the alimony was going to end at some point in time. So, as Attorney Nigro was saying before, all these cases are fact specific, but I'd want to know, they've known that this was going to end. What have you been doing to prepare for it? Have you been going to community college? Have you been, getting any licenses so you can be prepared for this moment? It's not a lottery. Getting married is not a lottery ticket. So there's got to be some responsibility on both parties to better themselves.
Well, correct. And at the end of the day, it is a legal contract that, frankly, I don't think enough people take seriously. I think it's a very sacred contract. But what I hear you say, and I want to make sure I'm correct, is that one party, because it could be either way, man or woman, knows that child support is ending. It is a legitimate question for the judge to ask them, what have you been doing to prepare for the end of this? I've lost the sound.
Yes, can you hear me? That's absolutely an appropriate question. I think we want to know, what have you been doing to prepare for this moment? You've been divorced for multiple years. Now the children are grown and emancipated, and you want the obligor to continue to pay. So what have you done?
Yeah.
So that's a legitimate question.
I mean, that's what I would think. I'm married, but I don't have kids. And so I'm always very curious about how this stuff works. And I have no intention of ever being divorced. So of us don't, but I don't. Anyway, well, thank you very much for your time, sir. You have a wonderful reputation and have had some stellar recommendations from different people I've spoken to. And I think that you take this quite seriously. I find, as well you should, but I find this particular court so challenging that I hope you have a strong support system for when you come home at the end of the day. And it's hard. It's a very hard thing, and particularly if a family is being broken up. I mean, that's never what we want. Nobody wants that. So thank you for applying and for offering your service to the Commonwealth. It's much appreciated.
Thank you, Counselor. I
Thank you,
appreciate your
Councilor
time.
Duff. Councilor Iannello.
First of all, thank you for taking your time out of your busy schedule, speaking with me. I was really impressed with you. You appeared to be extremely knowledgeable, professional. I have no doubt that you're going to be a great addition to the probate court. I'm enthusiastically going to vote for you next week.
Thank you.
I had every intention not to ask you a question today. But unfortunately, because of Attorney Nigro, I got at least, I mean, we went over a lot of issues, but
You'll pay later.
again, with all due respect, he's very, you know, he didn't come close to answering my question. I don't think many people up here thought he would get close to answering. But I'm gonna try to make it a little easier for you. Let's assume the wife is making $250,000 a year. The husband's not working. They have no children. The husband was working. They've been married 20 years. The husband was working in retail and as a paralegal for 5 years. The last 15, 18 years, he hasn't been working. He is 100% healthy. They've agreed over the years that there's no reason he doesn't want to work, doesn't like working. Help me out. What additional, give me a fact pattern that would assign an earning capacity, at least a minimum wage, to that husband. You give me the fact pattern.
Fact pattern is what you just told me. He doesn't want to work. I'm sorry, he doesn't want to work. He's a healthy individual. He's got I assume he's been worked as a paralegal.
I'm sorry, let's go. Yeah, he's got a college,
got a
four-year college degree.
4-year college degree. He's worked at a paralegal and he's worked in retail. Okay, so there is going to be an earning capacity to that individual. We will start with all things being he's healthy, all other reasons. Yes. And she didn't hold him back. She didn't tell him he couldn't work because he had to stay at home and prepare for, business dinners that she had to, he wasn't doing that. He likes to play golf. He's getting his handicap down, or work out or whatever he's doing, go to the beach. There will be an earning capacity there. Again, I don't think that you don't hit the lottery by getting married to someone who's making a lot of money, and therefore you don't, there's got to be some personal responsibility. Certainly alimony is in play, and certainly there's more than likely, based on the earning difference and all the Section 34 factors is going to be alimony. But we're going to start with,
let's say, not to interrupt you, let's say we're almost done. This husband, is a high school dropout, and then he's a 4-year college.
Okay.
Well, how would you?
High school dropout, we're going to apply basically minimum wage, 40-hour week, 50 weeks a year, and whatever that number is, we're going to use that. And as Attorney Nigro said, at the end of the day, the impact on the number is probably not going to be that significant, but too bad. It's going to be taken into consideration. For the guy who's a college graduate who hasn't worked, and that's more difficult, obviously more difficult, but it's going to be more than minimum wage. And as you and I spoke, first thing I'd do, and they are public records and we can rely upon them, is statistical data from the Department of Labor. And I'd start looking at those and see what I can, where does this guy fit in?
Thank you. But it's definitely under my hypothetical, the wife weren't earning $200,000 a year. This husband not working, but a 4-year college degree. That's going to affect alimony.
Absolutely.
Yes.
It's the dynamic. It's not fair that she should be going to the office work. When I leave early, when my wife's preparing for trial, I feel guilty. I mean, so she shouldn't be going to work while her divorced husband is not. There's going to be an impact.
I agree, and I won't ask you.
I'm not prejudging.
I hope Attorney Nigro board someday whether you agree or disagree with you, answer the question. And
he loves defense.
I have no idea. What you talking about? But we do have a few things in common, and I didn't know until about a half an hour ago. Let's start with number 1, Suffolk Law School.
Yes.
I went to Suffolk Law School. That's good.
Yep, 91.
I'm a little older than you.
Okay.
We have more. Trinity College. I went to BC, but my son went to Trinity and he loved Trinity. He's now, unfortunately, he's a lawyer. He's working in Germany. He applied for the stupid job and he got it. So he's in Germany.
Yeah.
We actually saw him and came home last week. We had a vacation. But he loved Trinity. How'd you like Trinity?
Well, my father would hate when people ask me, how'd you like Trinity? And my first answer was, I had a great time. So I will not leave. Well, I guess I led with that. I loved it. I had a great 4 years there. I played hockey there, which was a great experience. And I almost went to BC too, but I think I'm very happy. Some of my best friends I met at Trinity College.
My other son went to BC. Okay, we have one other thing in common. You'll never guess it. Spinny Yellow Construction,
Yes.
Columbus Ave. And I agree, those were tough jobs. Those were lawyer jobs.
Did you work there?
You better believe it. I know, I was thinking of that. He told me his name. Again, I'm a lot older than you.
Spadoni, the Spadonis, Dickie Sullivan.
Who was the guy from Water and Sewer? He used to come by. That was a
John Sullivan.
John Sullivan.
Yeah.
What a nice guy he is
Oh,
too.
yeah,
I
absolutely.
remember, and his father,
Yeah, Pappy.
huh?
Pappy, they call him.
Whatever, but his father.
Yeah.
Yeah, my supervisor there was,
Dewey.
no, it was John Cadigan.
Oh,
Cadigan, but they had the yellow trucks, am I right?
yep, they had yellow trucks then.
I was Columbus Avenue.
Yep, put the bypass down and then,
Oh, those friggin' pipes.
they never heard of OSHA.
Huh?
They never heard of OSHA.
I never heard of that. Those were tough jobs. I also worked, not to bore you, but yeah, those are,
That's great.
That's about how-
Finally met someone who, yeah, that's great.
but you know what? You take those jobs. I also work for Susie Construction. They're the attorney construction. You need money for college, and you know, for law school. But hard work, it really tells you what a person's like when you can do that type of work. After working, I'm almost done. After working for Spinny Yellow Construction, then I had to hurry up and walk down, I forget what train station on the Orange Line, go to the Suffolk Courthouse, okay, and then I was a janitor at night from like 5 to 7:30. Then I had to go all the way home. It was a tough day. I'm exhausted
Yeah.
at the end of the day, but
Those are tough hours, tough.
those were tough. But again, thank you for answering all my questions yesterday, the day before. Looking forward to voting for you, and I'm sorry to everyone else. I took too much time with the witness. I think he's got to bear a little responsibility for that. But I look forward to voting for you. next week.
Thank you very much. I appreciate it.
I'm done, Marilyn. I'm done. Thank you.
We spent a long time together in my office.
I appreciate it.
Most of my questions. And as I said, when I was questioning the witness, there's no question that you're qualified for the job, and I'm going to vote for you. I just got to ask you one question, because I was reviewing your governor's council question. What percentage of your practice is in the probate court?
Like 95%. I can't remember what I put down there, but 95, I'd say.
Do you have it?
Yeah.
Take a look at page 9.
Do we have a typo?
I think we have a mistake there, because I was scratching my head. Yeah.
Well, you know,
It didn't seem right to me. Number 3.
okay, yeah, you know, I was thinking actual probate as in wills and trusts, and that the civil was the domestic relations side. That's what I was thinking.
Okay,
That's how I thought.
so it's basically then, because as it reads, it says you've only done 5%, as I read it in the probate court.
Yeah, that would be 100%.
That's 100%, because you were combining the civil with the probate.
Yeah, yes, correct.
Okay, you
And civil,
treated
I was
it-
counting as domestic.
They treated the divorces as civil and the
Or
probate as
uncivil.
the death cases.
Yes, correct.
Emergency, okay.
Thank you.
That just confused me. But as I said, I spent a lot of time with you in my office. You answered all my questions. You have an incredibly great demeanor. You have a great knowledge of the law, have a great deal of experience, and I absolutely look forward to voting for you next week.
Thank you very much.
Thank you.
Councilor Jubinville.
Maybe this might
Excuse me?
I'm sorry, this might be a good place to break.
Okay, is Lieutenant Governor going to be up here? Okay, we're going to take a break now for our weekly assembly with the Lieutenant Governor. You can stay, you want to sit over here with your wife, and it'll be brief, and no one has to leave.
Great,
Thank you.
thank you.